Understanding Connecticut's statute of limitations for car accidents and wrongful death claims after a collision or the loss of a loved one. The law gives you only a limited window to act. Connecticut's statute of limitations sets firm deadlines, and missing them can permanently bar your claim. Because the rules are strict and often confusing, it is critical for Waterbury residents to consult an experienced attorney quickly. Most motor vehicle accident claims fall under General Statutes Section 52 to 584. This law requires an injured person to file suit within 2 years of when the injury occurs or is discovered, and courts routinely dismiss cases filed after the deadline. A discovery rule allows the 2-year clock to start when you knew or reasonably should have known of your injury, but a separate 3-year statute of repose imposes an absolute cutoff from the date of the crash. Even if an injury is discovered later, it cannot revive a claim once this 3-year period ends, so contacting a lawyer early is essential. Wrongful death claims have a different timetable. Under Section 52 to 555, the representative of the deceased person's estate must sue within 2 years of the date of death. A 5-year statute of repose, measured from the date of the negligent act, bars claims brought later. This rule can cut off the rights of families when an injured person survives for several years before passing. The Connecticut Supreme Court has held that the 5-year cutoff is absolute. One narrow exception exists. When the at-fault party has been convicted or found not guilty by reason of mental disease or defect of serious crimes such as murder, felony murder or manslaughter, the 5-year limit does not apply. Connecticut does not pause its deadlines for injured minors. The same 2- and 3-year limits apply, so parents must act on behalf of their children within those periods. Claims involving government entities require even more urgency because written notice must often be given to the municipality or the state within a short period, and failure to follow these procedures will bar the claim. If the at-fault driver lacks insurance or has too little coverage, your uninsured or underinsured motorist claim proceeds under your own policy. These contractual claims are not governed by the 2-year negligence statute, and state law prohibits insurers from limiting the time to file to less than 3 years from the accident. You can extend that period by notifying your insurer of a potential claim and pursuing arbitration or a lawsuit after settling with the at-fault driver's insurer. If the at-fault driver's insurer denies coverage or becomes insolvent more than 2 years after the crash, you have 1 year from the denial to act. In rare situations where a defendant intentionally conceals their wrongdoing, the statute of limitations is paused until you discover the claim. These deadlines are unforgiving. Once a limitation period expires, the right to pursue compensation is lost forever. Acting quickly allows your attorney to preserve evidence, document your injuries, and meet every requirement. Prompt action gives injured people and grieving families the best chance to hold negligent parties accountable. Dan Petroskey, owner of DeFronzo Petroskey, P.C., has more than 2 decades of experience representing clients in motor vehicle accidents, slip and fall cases, and other personal injury claims. As a trial lawyer and lifelong Connecticut resident, he combines careful preparation with compassion for his clients. The law firm carries a 60-year legacy and has been recognized for excellence by best lawyers and super lawyers. DeFronzo Petroskey, P.C. offers local insight, proven results, and personal attention to clients throughout New Haven County. Their office is located at 255 Bank Street, No. 2B, Waterbury, Connecticut, 06702, and the phone number is 203-756-7408. Contacting this law firm promptly can protect your rights and move you closer to justice.